Commodities, Revenue and Customs, and Frank A. Smart and Sons Limited.
May it please my lords and my lady, I appear with my learned junior, Mr. Anderson, for the appellants, the commissioners, and my learned friend, Mr. David Small, appears for the respondent, Frank A. Smart Limited, or FASL. As I understand it, there's only one piece of housekeeping, and that is my learned friend has passed up to your lordships and your ladyship a copy of the 3 questions that were referred by the Court of Appeal in the Cambridge case. That reference is before the Court of Justice. There is no hearing date listed for it. There is going to be no Advocate General's opinion, and therefore the judgment could come out effectively at any time. The written procedure closed.
So effectively they regard the answer as obvious.
That is one possible inference.
Yeah. Well, I think that under the rules they can only dispense with an opinion of the AG if the answer can be deduced from existing jurisprudence.
There are certainly rules in the rules of procedure to that effect. With your lordships and your ladyship's permission, I'm proposing to advance our positive case as to why the input tax in this case is irrecoverable. Like Caesar's ghoul, my submissions will be in 3 parts. The first submission, main submission, will be that there is a direct and immediate link between the expenditure on single farm payment entitlement and the receipt of the subsidy, and it's common ground that that activity is non-economic activity, but a little bit more, I think, needs to be said about why that is. My second main submission will be that input tax that is directly and immediately linked to a transaction which constitutes non-economic activity and therefore is outside the scope of VAT cannot be deducted. My third submission will be that there's no scope here on the facts for recovery of the input tax as a general cost or an overhead of the business. Now, those 3 core submissions essentially replicate grounds 1 to 3, albeit that ground 3, the question of what place does intentional motivation have in the scheme, is necessarily interwoven into each of those submissions. So for presentational purposes, I don't want to go to each case more than once, and so I've chosen to depart with that to that modest extent from the grounds of appeal themselves. Before I move on to the first part of that tripartite structure, there are 2 separate key propositions that I would like to lay out up front. The first key proposition is as follows. If costs are incurred directly and immediately in relation to an exempt transaction, that would not create a general overhead for other taxable parts of the business, even if the outcome of that exempt transaction was that it produced funds which the business then used by way of subsidy for its downstream taxable activities. In short, input tax that is attributable directly to an exempt supply is not recoverable, even if the motivation behind that transaction is to provide funds for the business and therefore for its taxable transactions. Now, I derived that proposition from the case of BLP, which the court will find behind tab 5 of the bundle of authorities. For the court's reference, the judgment starts at page MS page 725 or page 435 internally within the Simon's Tax Cases report. I'd like to pick it up, please, with the relevant facts, which can be found at paragraph 3 of the judgment, MS page 725. Please would the court read paragraphs 3 and 4, a summary of the key facts. The question that was referred by the High Court is set out at paragraph 11, but in characteristic style, the court then went on to deal with the questions not necessarily in that direct order. At paragraph 12, it started summarising the contention that was advanced by the taxpayer in that case, which was that the 6th directive had to be given a wide interpretation so as to include within its scope the VAT due or paid in respect of supplies of goods or services directly or indirectly linked to the taxable person's taxable transactions, including exempt supplies of goods or services which are used for carrying out taxable transactions. In the present case, it was said that the services supplied in the connection of the sale of shares were used for the purpose of raising the funds necessary for paying BLP's debts, which derived precisely from the taxable transactions it had affected. So in a nutshell, very much a similar argument to the one that's being raised here by Frank Smart was being raised by BLP. BLP then raised some subsidiary arguments at paragraphs 13 through to 15, and in 15 in particular, it observed, well, if we'd done things differently through taking out a bank loan, the consultancy services which gave rise to fees incurred in relation to the procurement of a bank loan would have been recoverable. So they said, therefore, fiscal neutrality mandates that we should have like treatment here. At paragraphs 17 to 28, the court roundly rejected that argument. Please could I invite the court to read, I'm afraid it's a long section, but paragraphs 17 to 28. This is, we say, an important case. Please could I then just pick out some salient points to support my submissions to the court. Firstly, when one sees in paragraph 19 the reference to the words use for transactions, that confirms that what one is looking for is a direct and immediate link with taxable transactions. The ultimate aim being pursued by the taxable person is irrelevant in that respect. So one's looking for a direct and immediate link between the cost components of a transaction and the output transaction, which is an output transaction that carries an entitlement to deduct VAT. That's also borne out by the wording of what was then Article 2 of the first directive, which focuses on the various cost components of a taxable transaction in the standard VAT chain of transactions. There's then a rare exception to that dealt with for exempt transactions. That relates to circumstances in which a person is conducting a financial transaction, for example, with a counterparty that is outside the EU. The sixth directive and now the principal VAT directive enable the person who is making that transaction to deduct input tax. It's a sort of fillip for the financial services industry within the EU. Paragraph 25 makes clear that the fact that you could have done things differently through procuring a loan in order to, in inverted commas, give funds for the business, close inverted commas, is not relevant because one has to deal with the transaction that is in issue and not with a transaction that could have given rise to different tax consequences. In that case, if the business had procured a loan, it would have been the recipient of a supply of credit, and therefore there would have been no input tax as such to be deducted. Whether or not if it wasn't an exempt supply of credit for whatever reason, it could well have fallen into the overall overheads of the business. If it was an exempt supply of credit, the cost of obtaining that credit ordinarily would fall into the overheads, but there would need to be potentially some form of partial exemption apportionment or business non-business apportionment, depending on the particular classification of the supply. But the court then went on to say in paragraph 26, it's for the trader to choose between the different ways of going about its business. The fact that they produce different tax results is neither here nor there. In this particular case, see paragraph 27, the costs were used for an exempt transaction. So they were a cost component of an exempt transaction, which was a sale of shares. The fact that that sale of shares produced funds, which the business could then use for its other taxable activities, was irrelevant, because the ultimate purpose of the transaction was not a relevant consideration. Now, turning, if I may, briefly...
Doesn't Mr. Small say that when we come on, as you no doubt will, to the Sveda case, we see greater respect given to intentions and purposes?
The Sveda case was dealing with a situation where there was a general cost of the business in the form of a purchase of a capital asset, a bit like a purchase of a shopping mall, for example. If a developer produces a shopping mall and then individual shops are located in that shopping mall, the initial capital outlay for the ground and the business development and the property development will be a general cost of the developer's business. That general cost is then designed to give effect to taxable activity, whether through the shops themselves producing goods and services which are sold to customers, or the developer itself selling on those business units to the extent that those are taxable transactions. So Sveda was a case in which the theme park that was built specifically with the intention of visitors turning up and spending money at the other facilities. And the court in that case found that that could constitute a general overhead of the business, and therefore it fell to be classified in that way. What's different about BLP is that you've got specific costs that are borne or used up or subsumed within an exempt supply of the sale of shares. They don't go anywhere else. They're used by that specific supply. And it wasn't appropriate to turn around and say they are general overheads of the business. There was a direct and immediate link with an exempt transaction. That was enough. Now, the court's reasoning in BLP has been applied in other cases. It's never been expressly doubted, to the extent that there is a greater tendency, perhaps in subsequent case law, to focus on whether or not there is a direct and immediate link with economic activity more generally. That isn't something that BLP has precluded. But at the same time, it simply wasn't something that arose in BLP because the costs in question weren't considered to be an overhead of the business. Also,
well, thank you. I didn't mean you to go massively out of your way, Mr. Beale, but we'll be taken to Sveda either by you or by Mr. Small, and we must look at what's there said.
Yes. I'm turning to Sveda next.
Oh, fine.
The Advocate General's opinion focuses in this case on the need for the expense on which input tax is based to be a cost component of the transaction. For your lordships and your ladyships notes, that's 30 through to 34. That's MS page number 720. So the Advocate General's approach is very much to look at what is the input tax being used for, which is a question of attribution. At paragraph 38 of the Advocate General's opinion, at MS 721, the Advocate General said this: on the basis of that attribution, the right to deduct input tax is excluded in the present case, it being of no relevance whether the sale of shares was for the benefit of the taxable activity of the taxable person on the basis of the discharge of indebtedness intended and effected. So the motivation for the transaction is irrelevant. What is sometimes described as intended use is dealt with in a different way in the case law. The clear wording of Article 168 of the Principal VAT Directive is that the input tax has to be used for the purposes of taxable transactions. And so that is the statutory text. The consequence, we say, of the BLP judgment, which has never been expressly doubted or indeed overruled by the CJEU itself. I accept entirely that they don't often overrule themselves, but they quite often make it clear that things have moved on. The CJEU itself has not done that. And so one sees repeated references in subsequent case law to BLP, which means it's established precedent rather than doubted precedent. But be that as it may, in our submission, BLP could not have been decided the way it was if Frank Smart's arguments were correct, unless there is some distinction to be drawn between an exempt transaction and a transaction which is outside the scope of VAT. And you'll have seen from the written cases that that was certainly a strand of reasoning which was adopted in particular by Advocate General Jacobs in a succession of cases, starting with Abbey National and then working on through. So the key proposition that we next advance, the second key proposition, is that there is in fact and in law no legal basis for reaching a different conclusion from BLP if the activity in question is outside the scope of VAT rather than exempt. Why? Because if there is a direct and immediate link to a transaction that is either exempt or outside the scope, input tax recovery is not permitted. And that, we say, is established by the Sveda case itself. So Sveda dealt with two things. Firstly, on what, can you apply the same reasoning from BLP, essentially, in relation to exempt transactions to transactions that are non-economic activity? And secondly, if there is no direct and immediate link with an output tax transaction that is taxable, can you, as a matter of attribution, say that those costs are attributable to the general economic activity more generally? Sveda is behind Bundle of Authorities tab 15. The judgment for your lordships and your ladyships reference is at MS 938. The background facts can be found at paragraphs 8 to 10 at page MS 939. Please could I invite the court to read paragraphs 8 to 10. At paragraph 15, the court recapitulated the reference question, which essentially dealt with whether or not there was a right to deduct in circumstances where the person had acquired capital goods, namely the theme park, in circumstances where there was a planned economic activity for tourism, i.e. they were going to get visitors in and sell them goods and services. So in a sense, it was a precursor to the ultimate supply of taxable services and goods. Paragraph 18, we see the court noting that from Article 168, insofar as the taxable person acting as such at the time when he acquires goods, uses the goods for the purposes of his tax transactions, he's entitled to deduct the VAT paid. So standard, straightforward principle. That's then modified somewhat in paragraph 20, where it relates not simply to tax transactions that you are at that moment conducting, but also to tax transactions or taxable transactions that you are intending to make in the foreseeable future. And so, by way of example, when one starts out as a barrister at the bar, frequently you have to buy a computer and a desk. You may not yet be attending court and doing anything taxable, but you incur that expenditure at the beginning of your practice. The HMRC will let you recover the VAT on it because it's expected that you'll be on your feet in court earning money on a taxable basis within the requisite period of time. So what the court said here is, given that the taxpayer was intending to have visitors to the theme park, the right to deduct VAT would arise immediately because the purpose of the transaction that he intended to carry out gave rise to a right to deduct. And that right to deduct arose at the time that the tax became chargeable. That's a slightly different question, with the greatest respect, from the question that we're looking at, because here the taxpayer already makes taxable transactions of farming. The only issue that this would go to would be the potentially planned expenditure on wind farm production. With the greatest respect, the wind farm issue is a red herring. Why? Because if the taxpayer is right that this input tax is attributable to its general economic activity, that general economic activity already exists. It already includes taxable supplies of the sale of cattle, for example, and that would be enough. They don't need to look to planned expenditure to fashion a remedy for input tax recovery. It's enough that they are already carrying on taxable activity if they're right that it's appropriate to look at the purpose for which you're intending to use funds that you've obtained from a separate transaction. So we don't need to go into the wind farm issue. The wind farm issue would raise the question of, are you intending to make those taxable supplies? But as I say, in my submission, we don't need to go there. It's sufficient that they are already making taxable supplies at the moment.
Does no issue arise from the disparity between the scale of the farming activity on the one hand and the scale of the receipts on the other hand?
That's correct, my lord, but that disparity would only go to the question of whether or not the financial transaction in question is potentially incidental to the taxable activity, so that it's not non-economic activity. If, for example, as is the case in a case called Régie Dauphinoise, you have a taxable supply of commercial property in the form of lets, it was a condominium, and the person who receives the rent for that commercial transaction holds the rent money on an account and uses the account money in order to generate investments and derives an income from that, then that was held in that case to be incidental to the taxable or economic activity of making supplies of property. And therefore there wasn't a distinct non-economic activity of making financial investments. That's one of the examples we'll come on to look at. That's to be distinguished, we say here, there is no case advanced against me that the financial investments in this case are merely incidental to the taxable activity of farming. That isn't the way it's been put. It's been recognised below that this is non-economic activity and that the SFPE is an input cost that gives rise to the receipt of the SFP, and it's recognised that the receipt of the SFP is a non-economic activity.
If you can look at intention, can you just run, I'm terribly sorry, can you run past me for my benefit again, why the taxpayer is not able to say, my intention is to erect a wind farm? And I've already looked into this in detail and spent 120,000 on it. Why is that not a permissible presentation of intention, if such is relevant?
It would be if the costs of the input tax that one is incurring, for example, professional fees on the planning application, which took place in 2014, one can imagine getting advice from a consultant for the purposes of the planning application. That bears input VAT on it. The taxpayer here could claim back that VAT with the intention of building a wind farm and making taxable supplies of electricity. That would be fine. The issue here is not that question, because we can already see that there is taxable activity of some form here in the form of cattle sales from 2007 through to 2012, 2 years before the planning application went in. So the question of intention is designed to enable a link between input tax that is incurred and future taxable transactions. So it's an answer, if the revenue were to turn around and say, well, hold on, you're not making any taxable transactions yet, the wind farm hasn't been built. Answer, no, but I have a sincere intention to build it, and I will be making those supplies, and because that's my genuine intention at the moment, I get recovery. And that's established on the case law. That's a very different question from our question, which is here the input tax has been incurred on buying entitlements. Those entitlements produce an income, so it's a form of investment instrument that produces a yield in the form of an income, and it's that income that the taxpayer is then seeking to use to say, well, I'm using that income for downstream taxable activities in cattle farming. So the proper analysis is, to what extent does that purchase of the SFPE constitute a cost component of cattle farming? That's the overheads analysis. We say you don't get to the overheads analysis because the purchase of the entitlement is subsumed or used up by, borne by, non-economic activity, which is the receipt of the subsidy. Why do you buy the entitlement? You buy it to get an income. What you do with that income is irrelevant. See BLP. What you can't do in this case, we say, is default into an overheads analysis by saying, oh, but I was planning on using that income for my downstream taxable activity either now or in the future. Because that, in fact, is using income. Income is not a cost, income is a subsidy. And the case law makes very clear, even Sveda, Iberdrola, all the other cases I'll come on to, the case law makes clear that you still need to find a direct and immediate link between a cost component and the taxable activity. So it's no good saying, well, there's a subsidy and therefore that is a component of the taxable activity. And that's where, with greatest respect, the Court of Session went wrong, because they focused on it being a component of a business without considering whether or not it was a cost component of the business. And we say, simply put, the receipt of income is a subsidy that helps with trading activity generally, whatever it may be, could help with all sorts of things, but it isn't a cost component of the cattle sales. And the point my lord made is, well, there's a disparity between the value of the cattle sales and the value of the income received, very gross disparity. That goes to make the point, evidentially, that that subsidy is an income stream in its own right. It's not a cost component of something that it costs far less than the subsidy that is designed to achieve it. So the disparity goes to prove evidentially that there is no direct and immediate link between the SFPE and the downstream cattle activity.
Could I raise two matters with you? One is simply a question of fact. The Statement of Facts and Issues, I think, agrees that the SFPs have been accumulated in a bank account and are held as cash. But it also appears that SFPs have been used, for example, to repay the borrowings that were required in order to purchase the SFPEs.
Yes.
So I'd like to be clear as to what the money has actually been, what the SFPs have actually been used for. The other point, I suppose, is related. BLP, the problem about deducting input tax seems to have been that there were supplies being made, of which those were a cost component, but they were exempt supplies. And so that was a sort of barrier. But in the present case, there aren't exempt supplies being made, are there?
So there's two, as I understand it, separate questions there.
Yes, two.
The first is, did BLP permit a general overheads analysis? Answer, no. Why? Because they treated the costs as being subsumed, used up, borne by an exempt supply.
Yeah.
They said it therefore doesn't go through to the economic activity as a whole.
Yes. And that's not our case, is it?
Well, our case is that there is no difference between an exempt supply and an outside the scope transaction, because both of them have to be treated the same way. Sveda establishes, as I'll comment on in a moment, that neither of them give rise to an entitlement to deduct. Therefore, in order to generate a right to deduct here, the taxpayer has to show a direct and immediate link, not with that particular transaction, but with the economic activity as a whole, which for present purposes will be cattle trading. I'm going to put to one side the wind farm because, as I say, it's a route we don't need to go down. If the taxpayer could establish a direct and immediate link between the purchase of the SFPE and cattle trading as a cost component of cattle trading, then that would satisfy the Sveda, etc. test for being a general overhead of the business. The reason why it can't do that is because those costs, that SFP cost, is entirely borne by the receipt of an entitlement to receive the subsidy. A subsidy is not a cost, and therefore the trader has to default to saying, well, it's my intention to use the income I've derived from this cost for a different purpose, which is a taxable purpose in due course or concurrently with trading. And we say that represents an interstitial stage in the analysis in the chain of transactions, because you have an input tax input, which produces an output in the form of the receipt of income. I accept entirely that it's somewhat conceptually difficult to view that necessarily as being a supply, and so the expression I've preferred to use is a non-economic activity or an outside the scope transaction. And I'll come on in the course of my main submission number 1 to explain why financial transactions are transactions that are either economic activity or non-economic activity. The VAT Act prefers the language of supply, but one sees from Article 168 that the expression generally used is transaction. Transaction better fits with a financial investment on which you incur input costs and which produce a stream of income as a yield. So it's a transaction. Is there any reason to think that the BLP analysis wouldn't apply to an outside the scope transaction as opposed to an exempt transaction? Answer no, unless you can somehow break the BLP reasoning and say it no longer applies. And that is something that the Court of Justice has never done. On the contrary, when one looks at SFEDA, perhaps cutting to the chase if I may, one sees, for example, at paragraphs 27 through to 29, an analysis which I hope is akin to the presentation I've just been giving, which is one needs to establish the existence of a direct and immediate link between a particular input transaction, here the purchase of the entitlement, and a particular output transaction, or transactions giving rise to a right to deduct. So that's the first stage of the analysis. What is the direct and immediate link between the input cost and a particular output? Now here, the input cost went to receiving a subsidy. The receipt of the subsidy was akin, as the Court of Session found at paragraph 27, it's akin to some form of financial investment. The wording in Article 9, subparagraph 1 is the acquisition of intangible property that yields an income on a continuing basis. And that would be economic activity. What happens here is that there's an acquisition of intangible property that yields an income, but that commercial activity is not on a continuing basis. And for reasons I'll come on to, the case law makes it very clear that that's then non-economic activity rather than economic activity, and it doesn't carry an entitlement to deduct input tax. We then see...
So if you place money with a bank on deposit and earn interest, is that a separate activity?
If it's an incidental financial transaction for your main taxable activity, it wouldn't be. If you are essentially making money as a private investor, receiving interest from a bank, then it would be separate and discrete, non-economic activity.
Thank you.
And how do you test whether or not it's incidental?
There's a series of tests set out in a case called Harness and Helm and the Wellcome Trust, which set out 3 circumstances in which investment activity will be economic activity rather than non-economic activity. One of those criteria is whether or not the financial transaction is incidental to the main taxable activity. There are a series of guiding paragraphs as to whether or not something is incidental or not, but it comes down to all the circumstances of the case. But it's not being suggested in this case. I've raised it to explain the overall framework. It's not being suggested in this case that this activity is merely incidental to the taxable activity. Why? Well, because of the disparity my Lord Reid identified between the very large sums of money made from the investment and the comparatively much smaller sums made from cattle trading. So,
well, that's where certainly to my mind, the wind farm might not be a complete irrelevance, because one can quite see that there's an enormous disparity between the income being generated from the subsidies because of the ability to leverage up the subsidies by reference to land other than the land on which you're actually operating a cattle business.
yes.
And the cattle business, but if you import the wind farm exercise, the disparity, at least at first sight, appears to reduce, if not indeed become eliminated, if the whole of the net income, and it is only the net income generated by the acquisition of the units, is ploughed into the wind farm.
So I've got 2 answers to that. The first one is a conceptual response, which is the purchase of SFPE was not a cost component of planned expenditure on the wind farm. The SFPE gave rise to the receipt of an income. The cost was used in the receipt of the income. What you do with the income, it could be a wind farm, it could be a casino, it could be an offshore oil rig. It doesn't actually matter what you're using those funds for, because BLP says you can't establish a direct and immediate link based solely on the intention the intended use to which, or the motivation for receiving the funds. You don't look at what you're going to do with the funds, you simply look at the transaction itself.
Well, that's because you don't look beyond the point at which you identify an exempt transaction, as I understand BLP.
But the same analysis, my lord, goes for outside the scope transaction, because if there's a direct and immediate link with a specific outside the scope transaction, then the same chain breaking consequences apply post ABSKF and SFADA. The second answer, if I may give it now, is the case that I'm meeting is not one in which it is suggested that these costs are incidental costs of financial investment for the purposes of intended taxable activity. Why do I say that? Because it was common ground below, and it's common ground in the written cases, that the relevant activity here is non-economic activity. And the consequences of my lord's argument would be that the financial investment was incidental to taxable activity, and there was therefore no non-economic activity. So you would essentially disregard the incidental financial income you generate from a financial investment that is inevitably wrapped up in a small part of your main taxable activity. So using the rents in order to generate an income when you're a letting agent. But the necessary consequence of that is a wholly different case would now be advanced by my learned friend from the one that is in fact being advanced. So the premise for the entire appeal would be radically changed. Now, I accept that there are many different ways the argument might have been run based on the facts and based on different facts, but with the greatest respect, we are dealing with what is the presented case here, and the presented case against us is that these can be treated as overheads because the intention was to use the funds either immediately or in due course for taxable activity. So it's an overheads analysis, it's not a this is economic activity full stop analysis. And that changes the framework of analysis. One sees in paragraph 32 of SFADA, at page 942, the case law of the court, it says, makes it clear that where goods or services acquired by a taxable person are used for purposes of transactions that are exempt or do not fall within the scope of VAT, no output tax can be collected or input tax deducted. In both cases, the direct and immediate link between the input, the expenditure incurred, and the economic activities subsequently carried out by the taxable person is severed. So they don't use the chain-breaking analogy that Advocate General Jacobs adopted, but they do use the analogy of severing the direct and immediate link. And then the court went on to say, however, that in essence, because the creation of the theme park was to facilitate the provision of economic activity and taxable transactions, the expenditure did not relate to activities which were solely outside the scope of VAT. And they said at paragraph 37, a taxable person has the right to deduct VAT paid for the acquisition or production of capital goods for the purposes of a planned economic activity related to the rural and recreational tourism, which are directly intended for use by the public free of charge and may enable tax transactions to be carried out, provided that a direct and immediate link is established between the expenses associated with the input transactions and an output transaction giving rise to the right to deduct. So you have to identify the cost component of the input transaction being linked to output transactions that bear an entitlement to deduct VAT. Here, that was the provision of goods and services to tourists who would be using the theme park, even though they were given access to the recreational path free of charge, and a supply that's made free of charge is not economic activity for VAT purposes.
In both the cases you've cited, there are two distinct transactions. In BLP, there was a transaction with the professional advisors who charged VAT on their services, and then there was a transaction involving the sale of the shares. And because that was not a taxable transaction, it followed that the input VAT couldn't be deducted.
Yes.
And in the case you've just cited, there was the transaction involving the construction of the path on which VAT was payable, and then there were transactions involving the sale of goods to visitors to the theme park. And that was a taxable transaction, and the input tax was therefore deductible. Now, in our case, Are there two transactions at all? We have the transaction involving the purchase of the SFPEs, on which VAT is payable. What other transaction is there? It follows from the purchase of the SFPEs that there's then a receipt of income. But is there a separate transaction?
So the analysis that the Court of Session gave at paragraph 27 is that this is akin to an investment. When a company invests in, say, shares or bonds, it is engaged in a transaction. Those shares or bonds produce an income yield. The question then is that company engaged in economic activity or non-economic activity? And that's the question I'm coming on to. My Lord's absolutely right that on the facts of this case, the input tax produces an income stream, and that is the end of it.
Yeah.
It's a bit like the purchase of an annuity.
Yes.
Yeah.
And it would be odd to look at the purchase of the annuity as a separate transaction from the receipt of the payments contracted to be paid.
Right.
No, I accept that entirely. And so I'm coming on now to look at the first strand of my three main arguments, to look at the analysis of how you treat investments that are made by a company which don't have the regularity or continuity of being trading in those investments. So one can postulate a share dealer.
Just before we leave this non-economic transaction idea, nobody doubts that the purchase of these subsidy units is an economic activity because it's vatable. And if there isn't any recognisably separate transaction involved in the receipt of the income from them, how can it be said that if it's all got to be viewed as a whole, we're talking about a non-economic activity? I mean, it's difficult to think of anything non-economic about the purchase of farming subsidy units by a farmer to subsidise the costs of his farming and wind farming activities.
The supply of the units is a taxable supply because the person who was selling it was a taxable person.
Yeah.
And because the supply of the entitlement was a supply of services, and because the supply of services did not, it was perceived, fall within an exemption.
Mm-hmm.
So it's no different, we say, from an investment in which somebody is buying, say, a bond, a fixed-term bond, which generates a yield. Mm-hmm. The reason why that's not taxable is because it falls within an exemption. If it didn't fall within an exemption, that would be a potentially taxable supply of a financial instrument to the recipient of the investment. But the income stream that on either case they receive is going to be determined either as economic activity or non-economic activity, depending on whether or not it represents a continuing commercial activity. Because Article 9, subparagraph 1, says that it's the exploitation of intangible property for the purposes of obtaining income thereon on a continuing basis that gives rise to economic activity. And so, following this example through, and I think this is where my Lord's question is going, if this was a taxable supply by a taxable person of the entitlement, and if the recipient of that entitlement was effectively commercially trading in entitlements, then the consequence would be not only that the subsequent sale of the entitlement would bear VAT, but that the receipt of the income would also bear VAT, because it would all be a taxable transaction from start to finish, and therefore the income would have to bear VAT. I asked the registrar to kindly pass up to you the example that was given of the Handguns Firearms Act legislation, where people had to surrender their firearms in return for compensation under a statutory scheme under the Firearms Act 1997. I hope it's made it to the court's bundle.
Yes, case of Stewart.
That's right. GT Shooting, I think, was the firm.
Yep.
And in that case, even though there was an element of compulsion about the surrender of the handguns, it was found to be a taxable transaction because there was the transfer of the entitlement in the property to people who were taxable, and from people who were taxable to the government. The government received the goods. The fact that it was part of a compensation scheme was neither here nor there. Now, if in fact the taxable supply of services that we're looking at is assumed to be taxable throughout, because it's part of economic activity, then the consequence of that would be that the supply of services would also carry output tax, and therefore the receipt of the income would have to have a VAT portion on it. much like the compensation award that was given to the people who surrendered their firearms, had to bear a VAT portion. So that, we say, the reason why that sounds strange is simply that so many financial investments are exempt. And to be brutally honest, I've struggled to think of another example where there's a taxable financial investment, which is why one doesn't have any analogous cases of particular help. What I can do, I hope, is take my lords and my lady to harness and helm to deal with this rather strange concept of a financial transaction being, in inverted commas, a supply, even though it's better characterized as a transaction rather than this specific supply from X to Y. This is behind Bundle of Authorities, tab 8. One can pick up the relevant facts at paragraphs 6 and 7 of the court's judgment, which starts at MS page 794. The relevant facts were that Harness held shares and bonds issued by bodies and undertakings in the United States and Canada. Because it's a financial transaction, therefore involving entities which are outside the EU, there was unusually a right to deduct input tax. And so Harness was saying, well, hold on, we are making these, engaged in these transactions, we're entitled to deduct the VAT on it in relation to them. Please would the court read from paragraph 11 through to paragraph 20, which sets out the court's analysis of this question of how do you go about categorizing for VAT purposes investments like acquisition of bonds. So that's 11 through to 20, please.
Does the analysis in paragraph 18 transfer entirely happily to the holding of units of this subsidy scheme? Because the entitlement to receive payment isn't purely something derived from the quotes ownership, quotes off, if that's the right word, of the unit. It requires you to comply with certain conditions on the ground, does it not?
There's certainly the agricultural requirement to have land in...
Not actually to farm,
no.
But it certainly requires you to keep the land in a certain condition.
No, but the tradable units float above the land ownership. So they are tradable in their own right. They don't have to be attached to any particular species of it.
But if I was to buy them and didn't own a hectare, or if I owned a hectare, didn't keep it in the appropriate condition, I wouldn't receive any income stream out of it, as I understand it. I could still buy it, but it would just be a waste of my purchase.
Yes, but I think that's absolutely right, my lord. The question becomes, to what extent is that a distinguishing feature from the analysis here?
Well, that's what I'm asking.
Of what's going on. In my respectful submission, what we have here is an entitlement to purchase something which gives rise to an income stream. The fact that there are conditions associated with it, as my lord's indicated, you simply wouldn't buy it if you couldn't meet those conditions. And so in practice, one has to accept that there might be conditions, for example, attached to the payment of interest under a fixed-term bond. the source of funding from the fixed-term bond may well come from a third party rather than from the immediate counterparty, if there's been an assignment. All of these factual wrinkles do not, in my submission, change the underlying analysis, which is you have bought something that generates an income stream that falls within the scope of Article 9, subparagraph 1, only if it's done on a continuing basis, or the other two examples in paragraph 16 are where, for example, in relation to shares, it's the management of companies in which the holding has acquired. So it's not simply passive share acquisition, it's active share management. That doesn't affect us here. The only other example is where the investments in question constitute the direct, permanent and necessary extension of the taxable activity. And that's what I've called the incidental financial transaction in my submissions earlier. So we say that this analysis certainly gives rise to the analogy with the purchase in this case. There's then, in any event, a subsequent case, EDM, which we say makes the position even stronger. My lords, my lady will find that behind tab 7. Again, the judgment starts at page 763. The activities of the taxpayer can be seen at paragraphs 17 and 18 at page 766. In short, EDM was a holding company in the mining sector. It engaged in various consortia contracts whereby it essentially tried to find mining opportunities in Portugal. Once it had found them, it would then set up a company to exploit that mining opportunity. And one sees in paragraph 17, it participated in 3 consortia, the sole purpose of each of which is to discover mineral deposits in 3 different regions of Portugal. EDM's activity in the context of each of those consortia consisted in technical activity, coordination of operations, participation in advisory council. So it's working behind the scenes to give effect to the project that they've identified. Paragraph 28. In the course of that, paragraph 23, the tax authorities in Portugal consider that dividends, loan interest, revenue from short-term treasury operations, including shareholder, and the proceeds of sale of shares and other negotiable securities were income. But they found that they were income which didn't derive from the taxable activities of EDM, so they refused to allow input tax recovery on it. The court's question is drafted at paragraph 29, where it reforms the question from the National Court. And the court was essentially looking at whether the financial transactions of a holding company, consisting in the annual granting of interest-bearing loans to companies in which it has a shareholding, in the sale of shares and other negotiable securities, and in other treasury operation, constitute economic activities within the meaning of Article 4.2. The court's response to that essentially started at paragraph 49. Please would the court read from 49 through to 54 to deal with this particular point, which concerns the nature of investment activities. At paragraph 56, the court then went on to look in slightly more detail at exactly what the income in question was. And it said, apart from the interest received by EDM in consideration of the loans granted to companies in which it has a shareholding, so it was granting loans to its subsidiaries, the National Court refers to the sale of negotiable securities and other treasury operations. It seems to be clear from the observations submitted, etc., that as it is in fact a matter of sales of shares and of holdings in investment funds, of payment of interest produced by bank deposits and by securities such as treasury notes and certificates of deposit, and of the yield from placements in investment funds. So this is much closer in my respectful submission to the case that we're looking at, which is if you place funds in an investment fund, it generates an income. That income can then be used by your business. The question is, does that give rise to something which is an economic activity or a non-economic activity? And the court answered that question at paragraphs 57 through to 60. Please can I invite you to read 57 through to 60. In terms of the placement in investment funds, that's then dealt with at paragraph 63. And the answer to that was that it did not constitute direct consideration for the supplies of services consisting in making capital available for the benefit of a third party. Like dividends, such a yield cannot be regarded as the effective exchange for services rendered. Consequently, those placements do not constitute supplies of services effective for consideration within the meaning of Article 2.1. They were therefore non-economic activity, and the income yield from them derived from non-economic activity on the part of EDM. In contrast, one sees at paragraph 65 that receiving interest, in answer to my lady's question, what is the position if you have commercial loans? The answer is, if you receive interest from a loan, that is economic activity. You're making credit available to your subsidiary, but see paragraph, I think it's 71, that would be an exempt supply.
So I'm just thinking aloud. From the point of view of the provider of the SFPs, that the supply of the SFPs is an economic activity on which VAT is due.
It's a supply of services which, in the absence of an exemption, is taxable.
On the other hand, from the perspective of the purchaser of the SFPs, it's the acquisition of an investment and is not an economic activity on his part, which would render him a taxable person if that was all he did.
Yes.
And that would be true of the supplier of an annuity transaction, I think,
Yeah.
that the supplier of the annuity would be carrying out a taxable economic activity,
Yes.
but the recipient might or might not.
Yes.
Yeah.
Absolutely.
And the subsequent payment of the subsidies, or subsequent receipt of the subsidies by the farmer in this case, is equally not an economic activity for the purposes of VAT.
No.
Yeah, I see.
It's income it receives in the course of non-economic activity.
Yeah.
And in order to make good my Lord Briggs's point, could I take you briefly to Wellcome Trust, where it was, I think, said to be the largest private share transaction ever outside of the government issue of shares. So largest private share sale was what was in issue. And the court held that didn't make it economic activity. In this particular case, Wellcome, the facts appear more readily, if I may say so, in the Advocate General's opinion at MS page 947. The Wellcome Trust, as I'm sure is well known, had very large sums held on trust for the purposes of promoting medical research and so on. it desired to get rid of a chunk of its shares in order to generate income, which would then be used in various different ways. As a matter of fact, one sees from the top of page 948, paragraph 5, that there were some taxable activities conducted by the trust. So, for example, it sold books, medical photographs and photocopies, and it was registered as a taxable person. That mattered, of course, because unless you're registered as a taxable person, you don't have a right to deduct input tax. So there was some taxable activity here, but the bulk of the input tax that it was claiming related to essentially advisory services in the course of the share sale. And the question was, is the trust's dealing in those shares and acquisition of other financial instruments economic activity or not? And the answer given by the court was that it was not. One can pick it up at page 958 of the manuscript, paragraph 21, which summarises the key question. The National Tribunal had sought to ascertain whether the concept of economic activity included purchase and sale of shares and other securities by a trustee in the course of the management of the assets of a charitable trust.
I'm so sorry, which paragraph you want?
Paragraph 21, my Lord.
Thank you very much.
Paragraph 23, one finds that the trust had pointed out that while investments made by ordinary investors do not come within the scope of VAT, the position is different where, by reason of its status or function which it exercises, an investor regularly makes investments for the purposes of generating revenue or increasing its capital. So again, one sees a common cause with Frank Smart in this case. So the Wellcome Trust was saying, we undertake these investments, they're very substantial in size, we're generating capital, generating income from that investment, and that enables us to conduct our overall business activity, some of which was acknowledged to be taxable. Now, the court's answer to those questions, and the reason why it found it wasn't deductible, because it related to non-economic activity, can be found at paragraphs 31 to 39. I'm pleased with the court read those paragraphs. That's 31 through to 39.
So this tells us that the receipt of the income is not an economic activity for VAT purposes. But you have to go a step beyond that and say that that furthermore, even if the income is applied for the purposes of a business which is VATable, that's not good enough to entitle the person carrying on the business to deduct the input tax.
Yes. If my learned friend's argument were right, that would have been an answer in the Wellcome Trust. They would have turned around and said, but I'm using these funds for the benefit of my downstream economic activity.
But was that argued or considered?
I don't actually know, I'm afraid, whether it was argued expressly or not. What I've taken you to is paragraph 23, which says in terms that they were making it for the purposes of generating revenue or increasing its capital. And I'm afraid what we don't have is the report for the hearing, which would have set out in greater detail exactly what the arguments were that were raised by counsel for the taxpayer in that case.
Well, it says, I beg your pardon, I'm looking at the wrong 23.
You may have been in the Advocate General's opinion, I'm sorry.
No, no, that's what I was looking at. Well, it's actually the same point being made in both paragraphs 23. The argument is perhaps clearest in the Advocate General, which is on MS 952. The appellant's argument that it was that its activity resembles that of pension funds and investment trusts. Now, but the point that if Mr. Small had been arguing its case would have been, well, it's not at all like a pension fund or investment trust. It actually uses the income from these investments in order to carry out medical research.
Yes. That would have been the argument. That wasn't any strand of the court's reasoning.
No.
And it may not have been a strand of the court's reasoning precisely because BLP had by this stage foreclosed, we say, that very argument. So the idea that the motivation behind the transaction you enter into is to capitalise or to fund the provision of downstream activity or downstream services, goods or services, is irrelevant.
Well, the problem we've been over this, but the problem in BLP was that the services for which the input tax had been paid had been used in order to carry out exempt supplies.
Yes.
Therefore, no recovery.
So here you've got a distinguishing feature, which is it's outside the scope activity, it's non-economic activity. It's difficult to put your finger on a particular supply, but certainly there are transactions which are resulting from non-economic activity held. You can't recover input tax on those. You're deriving income, but it's an incidence of property. It's not consideration for any particular supply to you, and therefore that's the end of it. You don't get input tax recovery on that basis.
Well, the argument against you is that there is the only supplies are taxable supplies of cattle, or one of these days electricity.
But the European Court in this case was not saying, we see that you've got some taxable activities, therefore you can have a proportion of your input tax that reflects the use to which those funds are put for those taxable activities. That would have been what I'm going to call the securenter answer to that particular issue. We'll come on to look at securenter in a moment. It's a case where there was a outside the scope issue of shares and silent partnerships. That gave rise to different forms of output transaction, some of which was non-economic activity and some of which was economic activity, and the court held you had to have an apportionment of the input tax between the two. So if my Lord's argument were right, that it's appropriate to, in a sense, see what is being done with the funds, then that would have led to an outcome from the court that said you can have a portion of your input tax, but not the whole lot. Now, I'm running slightly short on time, so I'm proposing simply, if I may, to draw your attention to 3 paragraphs in particular in the Court of Session's judgment, where, with the greatest of respect, we say they erred. The first is, for your note, if I may, towards the end of my submissions, I'll draw your attention specifically to the Court of Session's judgment and rattle through the various points I've got. But I'm afraid I've still got quite a lot of ground to cover. The 3 paragraphs in question that deal with this first strand of my argument are paragraph 23, paragraph 27, and paragraph 28. And in essence, we say that the error with respect is to say that there was no separate activity here, which was non-economic activity. You remember that the Court of Session has bundled all of the business activity together. It didn't separate out what we say are non-economic investment activity through the acquisition of the entitlement, and it should have done. Now, the next responsive point to make, and I'm afraid this is me getting my retaliation in first, but I'll draw your attention to the argument and then let my learned friend develop the case law, if I may. My learned friend says, well, actually what's in issue in this case is the receipt of a subsidy. The subsidy comes from the government. There's no consideration for that supply. Therefore, it's not a supply full stop. It's therefore easier to look through the absences of a supply and look at the downstream economic activity. Well, it's right, we say, that if a government gives you money without getting anything back, then that won't be a supply of services for consideration. So the initial allocation here of the entitlement, I think 194 units or so, wouldn't have been a supply for VAT purposes. We say it's different, however, when the focus is necessarily not on the receipt of the income in isolation, it's also on the input tax. Why are we concentrating on the input tax? It's because that is what the taxpayer wants back. That input tax was incurred in return for something. They didn't spend whatever the sum may be, 5 million odd, on the receipt of entitlements in order not to be very confident that they would get the income back as a result. So we have to look at the transaction as a whole and not simply focus on the receipt of the subsidy, which would otherwise give a very skewed view of what's going on here. And I've just taken you, I hope, to the case law that establishes where, as here, we're dealing with a form of investment, as the Court of Session rightly identified in paragraph 27. That investment activity reflects transactions, not necessarily supplies, because that may give a somewhat misleading view of the extent of the case law. But it's certainly dealing with a transaction which is outside the scope of VAT, and it's the correct classification of the input tax incurred on that outside the scope activity that is in issue here. And so the greatest respect is no answer simply to say there's no supply here at all, because that is to misconstrue the case law that we've just spent a little while going through. What is in issue here is the payment of VAT on a supply of services that was taxable and which generated or yielded an income. But that activity is non-economic activity for VAT purposes. We then end up with the second strand of my main submissions, which is that the input tax in question was paid in order to obtain the entitlement from one legal entity to another. The next question, logically, is to consider what was that input used for, what was the cost incurred in order to generate, and therefore to try and identify an output transaction that used that cost as a component. Now, the test for attribution is set out in the Midland Bank case. Given that time marches on, perhaps I could simply take you to the paragraph that establishes the principle. It's behind London Authorities tab 11. And if you would turn, please, to paragraph 20 of the judgment, which is at page MS 839. The test for a direct and immediate link begins at paragraphs 20 and 21. Please, would your lordships and your ladyship read that? That's 20 and 21. There was then an attempt to deal with whether or not it was possible to put more flesh on those bones. Answer, no. See paragraph 25. So I regret to say that the direct and immediate test is rather unfocused or broad, depending on whether you want to be charitable or not. But the court declined to give further guidance, saying it would depend on the facts of the case. What we do see, however, from paragraph 30 through to 33 is a slightly better explanation of what the court had in mind, citing yet again BLP, paragraph 19, said that the right to deduct VAT charged on such goods and services presupposes that the expenditure incurred in obtaining them was part of the cost components of the taxable transaction. Such expenditure must therefore be part of the cost of the output transactions which utilise the goods and services acquired. That is why those cost components must generally have arisen before the taxable person carried out the taxable transaction to which they relate. So one of the issues in this case had been legal costs were incurred, but they were incurred in defending a legal claim which would have been defended in any event and therefore had nothing to do with the taxable transactions that were going forward.
That was paragraph 19, was it?
That was of BLP, my lady.
Thank you.
Paragraph 30 of this case.
Paragraph 30 of this one.
Thank you.
I'm sorry. And so the focus is very much on the cost component. And one sees then at paragraph 31, there is in general no direct and immediate link in the sense intended by BLP between an output transaction and services used by a taxable person as a consequence of and following completion of the said transaction. Although the expenditure incurred in order to obtain the aforementioned services is the consequence of the output transaction, the fact remains that it is not generally part of the cost components of the output transaction, which Article 2 requires. So it's not simply a case of does the cost follow on from the input, does the output transaction follow on from the input? You have to have the cost component element to it in order to generate the right to deduct.
Well, then they come to the alternative general overheads analysis.
In paragraph
31.
Yes. They say even though you couldn't therefore link it to the specific transaction in question, which was one of those financial transactions where exceptionally you had a right to deduct, they said it nonetheless would fall into the general overheads of the business. Such a taxable person, in the context of activities which are no more than the consequence of making such a transaction, unless that person can show by means of objective evidence that the expenditure involved in the acquisition of such services is part of the various cost components of the output transaction. That's what it says at the end. So there's still, even if one is looking at whether or not it's a general overhead, the key link is between the objective connection between the input tax that you've incurred and output transactions which bear an entitlement to deduct. That can be the economic activity more generally, but you still need to show it's a cost component of that. And here we say it's not possible to suggest that the SFP units are a cost component of the supplies of cattle. In terms of the more basic proposition, the overheads analysis has been dealt with by the Court of Appeal, by Lord Justice Carnwath, as he then was, in Mayflower. My lords and my lady will find that behind tab 18. Could I please just invite you to read very quickly some paragraphs that deal with how the overheads analysis may arise. It's at MS page number 995. And if you'd be so kind as to read paragraphs 23 through to 28, one sees his lordship referring to a series of cases that deal with the distinction between specific costs attributable to a specific output transaction and general costs attributable to the activity as a whole. But there is a slight wrinkle in the terms of the overall analysis. So that's 23, please, through to, in fact, 29, if you wouldn't mind.
If Mr. Smart were to use the accumulated income from the SFPs in order to construct a wind farm and sell the electricity, why would the cost of acquiring the SFPEs not form one of the components of the price of the electricity? I mean, leaving aside the possibility that prices for electricity may be fixed by government.
Because the SFP itself produces an income, and it's the income that's then applied to the, effectively to pay for the acquisition of separate costs, which are acquisition of the turbine, acquisition of an electrical link, and so on. The costs of the downstream activity are the costs that relate to the production of the electricity wind turbine. Income is not a cost. So they could, for example, have obtained a loan.
No, not the income, but the price of acquiring the SFPEs. Why shouldn't that be a cost ultimately?
It has to be a component cost in the sense of a direct and immediate link between that cost and the specific activity.
You say the link is just too remote.
The link is broken by the receipt of income. So I can receive income in any number of ways. I can have a director's loan, I could have a shareholder loan, I could have a commercial loan, I could sell shares, I could issue shares, I could decide to sell part of my business as a going concern. Each of those ways of providing funds for the business would generate a different tax classification for VAT, and each of them has. So the examples I've just given are all in the case law. And here, what has been done is an investment has been made in the sense that there has been the acquisition of an instrument which produces an income, a yielded income. What the business does with that income is entirely a matter for the business. The fact that it uses the funds generated from that transaction for downstream activity is not a sufficiently close connection because it's not a cost. The cost relates to the production of income. The income could be used anywhere. The income, even if it is in fact used for downstream taxable activity, doesn't therefore form part of the cost basket for that activity. So if, for example, one were viewing this from a regulatory economic perspective, if, for example, Ofgem wanted to put a price cap on the amount that could be spent by a business erecting a wind farm or capped the amount of income that could be generated from electricity production, they would look to see what the component costs of that wind farm were. Income would not be a component cost.
But if a farmer is simply carrying out wants to carry out a farming business on a 200-hectare farm, I can't do so economically profitably unless he gets a subsidy. So and he can't get an initial allocation. Let's suppose that stage is passed, so he's got to buy the units in off the market. Why isn't it sensible to regard the cost of buying in the subsidy stream as a cost of generating profits out of that farming business?
So the
and
way
making supplies of whatever it is you farm, in this case, cattle.
The way that the argument might be run, hasn't been run in this case, would be I've got a 200-hectare farm, I farm cattle. In order to be able to do that, I purchase an SFP entitlement, which gives me a subsidy. That financial investment is the direct, necessary and permanent extension of the taxable activity. The investment activity is therefore economic activity on one of the categories that I showed you in harness and helm, and you simply ignore the incidental financial transaction, because in context, the financial transaction is giving aid to the taxable transaction. It isn't an activity in its own right. It's incidental to a taxable supply. Why doesn't that analysis apply here? My Lord has had my answer earlier, which is, firstly, the nature of the activity here isn't purely incidental. The magnitude, this is where the magnitude point comes in, the magnitude of the subsidy that was received shows very well that it was an income generation activity which was outside the scope and not simply incidental to the raising of cattle. It went way beyond what was necessary for the raising of the cattle. So it's an activity in its own right. That activity is non-economic activity, therefore you can't have the harness and helm incidental financial transaction applied. The second reason is a more prosaic one, which is that isn't the case that's been run. And for better or worse, that's where we are. The reason why...
But in the example I gave you, it would be no answer to say, oh, well, it generates income and therefore it can't be a cost.
It would be an answer to say it was an investment that went beyond the mere instance of property because it had a direct, necessary and permanent extension of the taxable activity. Therefore, it would be economic activity for VAT purposes rather than non-economic activity. And here, we're dealing with non-economic activity and not economic activity. So the answer would be, on the facts that my Lord has put to me, a different VAT analysis would necessarily apply to that which was common ground below and which has been common ground in the written cases here, namely that the relevant activity of obtaining the subsidy is outside the scope of VAT. Mm-hmm. So it would be a different way of arguing the case. Whether or not it would work on the facts would be dependent on whether or not the taxpayer could satisfy the rather loosely worded test of what constitutes a direct, necessary and permanent extension of taxable activity. But the case relied upon would be Régie Dauphinoise, which is the letting agency case, and it's telling, we say, that that case has not been put before your lordships and your ladyship.
Yes, so it's not the revenue's position that if they succeed in this case, it follows that that input tax paid on SFPEs are is universally non-recoverable by farmers.
No, we would analyse the facts of each individual case in order to determine whether or not the criteria for economic activity were met. And we're saying it's not beyond the realms of possibility that they might be. You'll appreciate my reluctance to speculate on individual facts, given that I would then be committing the revenue potentially to a policy position. But certainly, conceptually, one can see a space for there being recovery because the investment activity is treated as economic activity following Harness and Helm.
I mean, the concern is that your argument might prove too much if it extended to the sort of circumstances that Lord Briggs has put to you.
My Lord, I agree entirely. Can I then please make the very short point, I hope, that where input tax is directly and immediately linked to a transaction that's outside the scope, it's irrecoverable. I think I need to do no more than ask you to note 2 paragraphs in the VNLTO case at tab 14. Tab 14, the bundle of authorities. It's a very long Dutch appellant, which is I've shortened to VNLTO. But the relevant paragraphs of setting out the principle are at paragraphs 27 and 28.
Page?
MS 921, my lady.
Thank you.
And in particular, paragraph 28 says, consequently, where goods or services acquired by a taxable person are used for purposes of transactions that are exempt or do not fall within the scope of VAT, no output tax can be collected or input tax deducted. So here, where you have financial transactions that are outside the scope of VAT, the input tax that's borne on them can't be deducted. Can I just deal in passing at paragraph 38 with one, I'm afraid it's rather abstruse point. So one of the issues here was, can you, if it's outside the scope activity, can you then say it's therefore not business activity and an output tax charge arises? Because if a company essentially gives away goods or services for free, it is making them available for private use. And there is a provision of the Principal VAT Directive that says that that then generates an output tax charge. And this is something that the Court of Session had relied upon as a safety blanket in this case. The answer from the Court of Justice was that you couldn't simply read across activity that's outside the scope of VAT as being akin to being for a private purpose. In paragraph 38, it said, it follows from these considerations that, as the Advocate General has noted, the relevant paragraph of the then directive is not intended to establish a rule that transactions outside the scope of the system of VAT may be considered to be carried out for purposes other than those of the business. So, in other words, outside the scope activity does not necessarily equal private use. On the contrary, it would be outside the scope of activity, which would be a commercial or business activity. It would simply not be within the scope of VAT. And one need only consider the welcome trust type of case to see why that is. That clearly wasn't non-business activity, it was clearly business activity. It was just business activity that's outside the scope of VAT. Much the same statement can also be found behind tab 9 in the case of Iberdrola. That case involved a company which was a developer which was proposing to build a series of flats on some land. The local authority said, if you're going to build those extra accommodation on that land, you're going to have to revamp the sewerage system and put a pump station in. So the issue was, does that mean that it's providing part of the services it received, construction services, free of charge, which would be an outside the scope activity, to the local authority? Therefore, you don't get the input tax back. The answer from the court was, as a matter of law, if there's a direct and immediate connection between the input tax and a supply that's outside the scope, you don't get recovery. One can see that at paragraph 30, at page 803, MS page 803. It says, where goods or services acquired by a taxable person are used for purposes of transactions that are exempt or do not fall within the scope, no output tax can be collected or input tax deducted. However, one could then look to see whether or not there was a direct link with the economic activity more generally, and the court at paragraphs 33, 34 and so on said, well, actually, this taxpayer necessarily has to upgrade the pump station and the sewerage system, because otherwise it can't conceivably produce the additional accommodation that's necessary. If, however, the upgrade to the sewerage system went far beyond or beyond what was needed for that particular taxable transaction to take place, then you would have to have an apportionment. So to the extent, for example, that the pump station that the developer built serviced, say, 700 homes rather than 300 that it needed, it wouldn't be able to recover input tax in relation to 400 out of those 700 homes. So you'd have that sort of recourse to an apportionment to make sure that you didn't have over-recovery of input tax on that basis. Now, the next case that bears reading is the case of Securenta. That's behind tab 12. This is a case which Learned Friend relies upon, but I rely upon also, and we say on a proper construction it actually supports our case. The facts are important. Please, would the court turn to page 857? And could we pick it up, please, at paragraph 11? So there's two separate things to be borne in mind. Firstly, what does Securenta do? And the answer is given in paragraph 11. It manages and sells, acquires and manages and sells real estate, securities, financial holdings, and investments of all type. That's the first stage. That's, in a sense, what its overall activity is. There's then the separate transaction issue, which is its acquisition of the capital necessary through the issue of shares and atypical silent partnerships. So, much like Kretz Technik, this taxpayer had issued shares. That is not even a supply for VAT purposes. It's transactions outside the scope of VAT. And the question was, can you recover the input tax that you've incurred on those transactions, that issue of shares and atypical silent partnerships, or is it irrecoverable? And one sees from paragraph 13, in the administrative proceedings, Securenta stated that as all the input VAT paid related to expenditure connected with the acquisition of new capital, it was deductible on the ground that the issue of shares was linked to the reinforcement of the company's capital and that the transaction had benefited the company's economic activity in general. Now, just pausing there are therefore going to be two different types of economic activity which are an issue. Firstly, you've got the potentially taxable activities or possibly exempt activities of acquiring, managing and selling real estate. And whether or not that's taxable or exempt depends on whether or not the taxpayer has opted to tax the commercial property transactions. But it's going to be economic activity one way or the other. And then you've got the investment activity, which is non-economic activity in this case. I paused there simply to point out that if my learned friend's argument is right, that you can simply look through the investment activity to see what is done with the funds, then you wouldn't need any form of apportionment at all. You'd get input tax recovery across the suite because you would have, well, subject to a partial exemption method, because you would have, for the sake of argument, economic activity, which was a taxable supply of land. You wouldn't take into account the investment activity. You would then look at the economic activity as a whole, and that would be sufficient. Why? Because on his case, the non-economic activity of receiving funds is not a supply that is worth looking at or a transaction that's worth looking at. You can default to what you do with those funds. That would apply here. That isn't, however, the answer that the court reached. The court turned around and set out at paragraph 23 what the relevant question was. I should say in passing at paragraph 19, there's an express reference by the German government that part of the capital acquired from the share sale was allocated to areas in which no business activity was carried out. That is to say, the acquisition of financial holdings. That's a specific point that the German government had made in that case. The court then said the National Court was essentially seeking to ascertain how, if a taxpayer carried out both economic and non-economic activities, the right to deduct VAT paid is to be determined. And the answer given to that, in short, begins at paragraph 28 and ends essentially at paragraph 31. Please would the court read those paragraphs. But the only portion that could be recovered was the portion that related expressly to the to the economic activity, be that taxable or exempt. And of course, if it was exempt, you'd have to have a partial exemption special method.
But they are looking downstream, aren't they, Mr. Beale?
They are, because this was a case in which there was an issue of shares, the input tax related to the issue of shares, and Kretz-Technik said, in those circumstances, it's designed to capitalise the business, and the business then is using that capital to make supplies downstream. That's what it uses that provision of funds for. But of course, that's a provision of funds that has no transactional element to it. It's an issue of shares which is not a transaction at all, as opposed to a financial transaction that triggers the receipt of income on a recurring basis, which we've seen from Harness and Helm and from EDM, is a transaction that is outside the scope of VAT. Now, I don't pretend that the analysis from Kretz-Technik is terribly easy to fit into a consistent framework across all cases. What I can say is that one way of explaining Kretz-Technik is that the issue of shares is not a supply of goods or services to anyone. It's a company formation method by which people subscribe to the company and therefore is treated as not being a supply for VAT purposes at all. So it's outside the scope of VAT in the sense that there is no output transaction at all to which any input tax could be attributed. In contrast, that in a financial transaction, you do have a distinct purchase of something, the investment itself, and it produces an income stream. And if that income stream is produced with continuity and in accordance with the commercial requirements of trading in investments, it would be an economic activity, not a non-economic activity. Whereas shares, the issue of shares never could be. The way that the court then suggested domestic courts deal with apportionment was very much in the spirit and ethos of the apportionment system for exempt versus taxable activities. You apply the same principles and you come up with what's called domestically a business, non-business attribution of the relevant input tax. The next case, I'm not going to do it justice, I'm afraid. It's a very complicated case and is frequently, if I may say so, taken somewhat out of context. It's the ABSKF case, which is behind tab 13. In a nutshell, a taxpayer wanted to sell shares that it had in a subsidiary, which was a managed subsidiary. Because it was a managed subsidiary, the sale of shares was going to be economic activity. The court, in fact, held that it was economic activity and that the VAT classification of the sale of shares was an exempt transaction. The reference was somewhat bedeviled by two factors. Firstly, the matter came before the Swedish authorities as a request for a hypothetical opinion, or an opinion in advance, a tax ruling in advance, before the transactions have actually taken place. And so the facts were somewhat obscure. And we see, for example, at manuscript page number 891, paragraph 61, that the referring court had managed to describe the costs linked to the services acquired by a SKF as both directly attributable to the disposal of shares, but secondly, having been part of the general costs associated with its overall economic activities. That obviously is not a terribly clear summary of the relevant facts, and so the court therefore went on to look at what would happen on both analyses. It's already by this stage dealt with the core points of principle if there's a direct and immediate link with a supply that's outside the scope at paragraphs 59 and 60. And it said, for example, at 59, where goods or services acquired by a taxable person are used for purposes of transactions that are exempt or do not fall within the scope of VAT, no output tax can be collected or input tax deducted. And that was dealing, we say, specifically in response to a suggestion that had been made by Advocate General Jacobs that there was a difference between exempt transactions which were chain breaking and outside the scope transactions which wouldn't be. And Advocate General Jacobs had said, if it's outside the scope so there's no supply, then there's no difficulty with looking through something that doesn't exist to the downstream economic activity. Here the court rejected that submission, and it said in both circumstances the input tax could not be recovered. At paragraph 60, it said, it follows that whether there is a right to deduct is determined by the nature of the output transactions to which the input transactions are assigned. So one has to look at what is the cost component that the input tax is being used for, what is the burden of that cost for the purposes of an output transaction. What the court then went on to say at 62 through to 68, and I'm afraid I'm going to have to deal with this probably mostly in reply, is that you have to give the same analysis to exempt supplies as to supplies that are outside the scope. So rather controversially at 68, for example, it seemed to suggest that you could get recovery of input tax for an exempt transaction insofar as it was a general overhead of business activity that was taxable. And what in fact the court was saying is if you have established that there is in fact a general overhead which can be attributed to activity that bears the entitlement to deduct, then you can deduct, even if there is a connection with a supply that's outside the scope because it's even if there's a supply that's exempt because it's an exempt supply of shares. So in essence, this is the counterpart potentially to BLP. BLP said on the facts, this is not a general overhead because the cost is subsumed by an exempt supply. What the court is here saying is if that's not right, if you can find a link, an objective link between the input tax in question and the general economic activity of the company which bears a right to deduct, then you can rely on the general overhead analysis.
It might be said against you that that your approach is fine as far as it goes. The investment income is used to purchase, for example, if we're talking about a wind farm, it's used to purchase the planning permission, the materials for construction, the costs of construction, the costs of pipelines and so forth. And those are the costs which are reflected in the price charged for the electricity rather than certainly the income, as you say, is not a cost. But what seems then to be left out of account is the cost incurred in acquiring the source of income. That is a real cost to the business, which has to be amortized somehow.
Well, the acquisition, for example, of a fixed interest bond would be subsumed by the bond itself. it would generate a fixed interest yield over a period of time. If that bond is treated as non-economic activity, then you couldn't then turn around and say, but the costs of acquiring the bond in the first place are part of the general cost components of the downstream supply. Why? Because the cost has already been used in producing the income stream. That's it. It's over. It can't then be categorized as being something that produces a separate cost stack or separate part of the cost stack for the downstream activity. In a sense, it's the income generated that benefits the downstream supply rather than being a cost of it. So the downstream activity would be more expensive but for the income.
I don't know. The answer may be that you still have a capital asset, and it should appear as one of your assets rather than in a profit and loss account.
Well, if it's producing an income stream on a regular basis, I'm not sufficiently qualified in accountancy matters to venture an accountancy opinion, but certainly as a matter of VAT analysis, if it's producing an income stream, then it is the acquisition of a financial instrument producing an income stream. And the only question is, does it produce that income stream on a continuing basis? And the way that that's been analysed under Article 9.1 is to consider whether or not the acquisition of the intangible property gives rise to the income stream on a continuing basis in the sense of commercially trading in it. And so if you had a trader who made its living buying and selling SFPE, we would be dealing with a different case. But here, turning, if I may, to paragraph 71 and 72, MS page number 893, the court made it very clear that a disposal of shares which was exempt from VAT does not give rise to a right to deduct. It then said, the fact remains that the interpretation holds true only if a direct and immediate link is established between the input services and the exempted disposal of shares as an output transaction. So in other words, if the cost of acquiring or disposing of the shares is entirely subsumed within that particular output transaction, that's an end of the matter. If the costs are fungible in the sense they've already been expunged in that transaction, then that's it. And then they went on to say, if on the other hand there is no such link and the cost of input transactions is incorporated of the prices of SKF's products, the right to deduct VAT charged on the input services should be allowed. Now, that raises the spectre of some sort of mechanistic way of looking at price. We're not suggesting that, not least because of the Volkswagen Financial Services decision of the CJEU. Clearly, you could have a price that's set by the market. What our submission is that the relevant cost that one is focusing on has to be part of the cost stack or a cost component of the downstream economic activity if you are to establish a general overhead. And here, as in SKF, if in fact it's subsumed within the exempt supply or the outside scope supply, there's no room for a general overheads analysis.
And 72 looks so wide.
Yeah.
How can you narrow it? What's the context which you say should lead us to treat it with caution?
But it says the costs associated with input services have a direct and immediate link to the taxable person's economic activities in circumstances where they are solely attributable to downstream economic activities. I mean, clearly, if there's an interstitial stage at which they've in fact been expunged in receipt of...
See, so it comes back. Everything comes back to the same point, really.
Yes. I mean, the focus I'm seeking to alight upon is, what is this a cost component of? Is it a cost component of something that gives rise to the receipt of income? Or is it a cost component of the production of cattle and sale of cattle? We say the answer is tolerably clear, that it's not a cost component of the sale of cattle. What it is a cost that is used to produce an income. That income then, at a separate stage of the analysis, helps with whatever the business may be, and it so happens that the business is the sale of cattle. But there's no direct and immediate link between the purchase of the SFPE and the sale of cattle. That, in a nutshell, is our case. My learned junior's reminding me that I have only 10 minutes with which to weary you with further submissions. I think I need to turn to the third point. I may well need to come back, I'm afraid, and unpack SKF in a little more detail, because my learned friend takes a radically different view of what it establishes than I do. But in terms of the overall analysis, true it is that in SKF, as the court will be well aware, the issue of shares was found not to be a supply or transaction for VAT purposes. It was outside the scope. Nonetheless, the court was prepared to look through that analysis and say, but the whole purpose behind this is in order to capitalise the business, and the business is carrying on taxable activity that is sufficient. We say that is not this case. On one view, it's the rather, in a sense, superficial distinction between the production of capital and the production of income. But on another view, it's simply, in that case, the court found that the relevant costs were not subsumed in an output transaction at all. The relevant costs remained costs of the business. They were costs to get the business up and running, much in the same way as in Sveda, the costs of acquiring the recreational theme park was a precursor to the taxable activity which was taking place. And the two capital acquisitions put the trader in a position where it was able to make income. They weren't deriving income from it. Now, in contrast, if a trader conducts a series of financial investments and derives an income from them, it's deriving an income. It's an income that you could look at and say, as you can here with the trader's accounts, part of the accounts relates to cattle sales, but a large chunk of it, the majority of it, relates to the receipt of subsidies.
But why should it be crucial that in one example, the money is all raised in one fell swoop and then used to construct the theme park? And in this case, the income is collected off a, let's suppose, 4 or 5 year income stream over 4 or 5 years, bundled together in a bank account and then used in one swoop to buy and set up the wind farm. Why should it make a difference for VAT purposes? Because
the issue of shares was considered in Kretz Technik not to be an output transaction that generated income. And VAT is a tax on turnover. And for these purposes, turnover is equated with income. So the analysis stems from the concept of funds being provided for a business. Funds can be provided for a business in myriad ways, in the way I've already indicated. What matters actually is the classification of the specific transaction in issue. And here, the transaction we're looking at is what I've described as an investment and a yield on an investment. It's the acquisition of intangible property. In Kretz Technik, in contrast, it was people subscribing share capital to the company, to the limited company. And that wasn't considered to be a supply of services in return for consideration which yielded turnover. So because VAT is a turnover tax, it fell outside the scope of VAT altogether. In contrast, one could look at, for example, the receipt of interest where it would be within the scope of VAT, and that would be a different analysis. But I accept, my Lord, that at face value, you end up with some rather artificial-looking distinctions. I accept that entirely. But that's the fiscal theme park that is VAT, as Lord Justice Sedley once put it. We're straitjacketed by the analysis that's given by a combination of case law and the Principal VAT Directive itself, which ascribes to different transactions different VAT consequences. And I think in MVM paragraph 45, the court said, well, that's just the luck of the draw. You can choose how you do your business. It may have different VAT consequences, but that's your lookout. I paraphrase. Now, the fact that the business receives a benefit from the funds that are received, in inverted commas, is not, we say, the test for whether or not there's a direct economic link with the business as a whole. Could I very briefly turn to Investrand at tab 22 of the bundle of authorities?
Page?
Could we pick it up, please, at page 1066? Sorry, 1065. In this case, what had happened, as one sees from paragraph 7 through to 12, is Investrand had sold some shares to another company, High Tech Sports. There was then a post-share distribution arrangement whereby they would carry on having some involvement in the business. A dispute arose. As a result of the dispute, Investrand had to incur legal fees. It then sought to deduct the VAT paid on those costs for the 1996 financial year. The question raised by the court was whether or not it could do so. The Court of Justice at paragraph 24, at page 1067, recognised that even if there was no right to deduct based on a specific connection with the output transaction, nonetheless it's also accepted a taxable person has a right to deduct where there's no direct and immediate link between an input and an output, where the costs of the service in question are part of his general costs and are as such components of the price of the goods and services which he supplies. Such costs do have a direct and immediate link with the taxable person's economic activity. So that's the definition of a general cost that we've seen previously. Then says, in the case in the main proceedings, it must be pointed out that in accordance with settled case law, the sale of shares does not in itself constitute an economic activity within the meaning of the 6th Directive, and they refer to welcome, EDM. Contrary to what Investrand has claimed, the steps taken by a taxable person on his own behalf to recover a claim or establish the value thereof cannot be treated as such an activity either. So the two activities in question upon which the input tax had been incurred were non-economic activity for these purposes. Why? Because they did not constitute the exploitation of property to produce income on a continuing basis, because any resultant gain derives merely from the status as holder of the claim in question and not the product of any economic activity. And the court then went on to consider whether or not if the input tax related to non-economic activity could be deducted. Answer, it couldn't. See paragraph 28. And then it went on to look at whether or not it could apply the general costs analysis. See paragraph 29 and 30 had the member states' governments weighing in. Could the court then please read paragraphs 32 to 35, which summarise the court's conclusion as to why it couldn't be classified as a general cost? Got two or three things I now need to deal with. The first is the critique of the Court of Session's reasoning, which ordinarily I suspect would have featured much more heavily in advocate submissions than it has done to date. I've sought to develop the framework of analysis that we say is correct, and it follows from that that if I'm right on that, that the Court of Session has gone wrong. Why?
You set this out quite fully in your written case, in fact.
I have. If your lordships and your ladyship are happy, I need say no more about it than please read again our written case. The next point is apportionment, which is ground 4. If your lordships and your ladyships note, in the case of MVM Magyar, Bundle of Authorities 26, paragraphs 36 to 37 and 46, so that's Bundle of Authorities 26, MVM 36, 37 and 46.
Page.
Sorry.
1133.
Put me on the hop. I'm very grateful.
Thank you.
It's clear an apportionment is needed if input tax is used for both non-economic activity and economic activity. And the height of my learned friend's case must be that this acquisition of SPFE has led to non-economic activity in the form of receipt of the subsidy and economic activity because it's subsidised or financed the downstream economic activity. And if that's right, then you've got two different income sources, one from the taxable activity, one from the subsidy. One reflects non-economic activity, one reflects economic activity, and at the very least you'd need to have an apportionment. That's the apportionment point. Final point is on reference. I anticipate that the court has read, or at least cast an eye on, the decision of the Court of Appeal in Cambridge University. You've had my updating piece of information that it's now gone to deliberation stage before the court. We say a very similar issue is raised in that case as is raised here, namely, if you receive income from investments that go to subsidise downstream taxable activity, does that give rise to a right to deduct? In that case, the only difference was the relevant input tax was consultancy fees rather than the acquisition of the investments themselves. But that's in part because the acquisition of the investments themselves were all exempt from VAT and therefore there was no input tax. And the curious feature of this case, which my Lord Reed has identified, is that there is an investment activity and it's taxable. And so you've got this initial charge to output tax by the person who has sold the entitlement, which looks odd. And there's no getting around that because one is used to seeing exempt transactions rather than taxable transactions. But the underlying analysis, which I've sought to set out, applies come what may. If you'd give me a moment. Nobody's tugging my metaphorical gown, so unless I can be of any further assistance, those are my submissions.
No, thank you very much, Mr. Beale. Ms. Ranson, do you follow? Thank you. Mr. Small.
My lords, my lady, before I begin the meat of my submissions, could I draw attention to the omission of some words from my written case? It is the written case for the respondent, paragraph 9, and that appears on page 98. MS page 98. Now, in paragraph 9, I'm quoting a passage from my learned friend's written case. In the fourth line, I say, the established jurisprudence of the CJEU linked to investment activity. Now, there are words omitted there.
Now confirms that input VAT.
Correct. Thank you, my lord.
Well, we've got there.
Thank you. Having said that, my lords and my lady, I would like to begin by just putting my case in a very short nutshell. And in a nutshell, my case is that the VAT system gives fully taxable traders, by which I mean those who only make taxable supplies, the right to recover all the input tax which they incur on the costs of raising finance, subject to two conditions being met. Firstly, the finance which is to be raised is to be spent on developing or expanding the business so that further taxable supplies can be made. And secondly, the finance raising exercise is an exercise which is outside the scope of VAT because, in particular, it involves no supplies whatsoever being made. Now, that is the irreducible minimum of my case. We'll see as we get into the case law that there is a wider variation to my case which can be defended, which would say that if the finance raising exercise involves some supplies which are outside the scope of VAT, then it is still possible for the trader to recover the input tax on the costs of the exercise. Now that proposition, the wider, looser proposition, is evidenced by the cases of Abbey National and SKF. Abbey National is at tab 4 and SKF is at tab tab 13. We've been there already. But there is an irreducible minimum which involves the funding exercise involving the making of no supplies whatsoever. And that's what I essentially adhere to.
So how do you put the wider proposition?
I beg your pardon?
How do you put the wider...
How do I put, well, I would put the slightly wider proposition is merely to say that the finance raising exercise is an exercise outside the scope of VAT.
Thank you.
And what the underpinning principle of my nutshell irreducible minimum is simply the principle of neutrality in VAT, which says that VAT is a neutral tax to a business which only makes taxable supplies. And making taxable supplies means that the outputs of the business all carry either standard rated or zero rated or some other rate of VAT, but none of them are exempt, and none of the output business supplies is outside the scope. Now, in the present case, it seems to be a matter of agreement that the funds which were raised by the annual claims to SFP were outside the scope and they did not involve any activity within the scope of VAT. I would like to look at a case which is one of two, which seems to me to explain the reason why the claims for and receipt of SFP are outside the scope of the tax and indeed involve making no supplies. And I refer to these in my written case. There are two of them which essentially establish the same thing. We need only look at one of them, I think, which is case of Mohr, M-O-H-R. It is at tab 25 in the authorities bundle. And if we merely take the facts from the head note.
Sorry, can I have a page number?
So, my lord, it's MS page number 1115.
715?
Treble 1.
Treble 15.
1115.
Yeah, thank you.
If we look at the head note to take the facts, we see that the taxpayer owned an agricultural holding on which he kept dairy cattle, and he undertook to discontinue milk production there, and he was granted a single payment by way of compensation under a certain EU regulation. And the German tax authorities tried basically to charge VAT on that sum of compensation. And if we go to the court's judgment at paragraphs 19 to 23, which are on MS page 1124, then we see what the court said about that. Paragraph 19, it should be recalled that according to the principles of the EC VAT Directive of 1967, VAT is a general tax on the consumption of goods and services. In a case such as the present one, there's no consumption as envisaged in the community VAT system. As the Advocate General noted, by compensating farmers who undertake to cease their milk production, the community does not acquire goods or services for its own use, but acts in the common interest of promoting the proper functioning of the community milk market. In those circumstances, the undertaking given by the farmer that he will discontinue his milk production does not entail either for the community or for the competent national authorities any benefit which would enable them to be considered consumers of a service. And so the court held that this grant compensation was outside the scope of VAT. And indeed, my lords and my lady, I would say that implicit in what we've just read was the idea that there was no supply here either. The farmer, in agreeing to give up milk production, was not supplying anything to the state in consideration of the grant coming from the state. And I say that the reason in our case why the SFP is outside the scope of the tax is exactly the same. Mr. Smart, in arranging matters that his company complied with the conditions for claiming SFP in respect of his various units, was not thereby supplying anything to the state. It was meeting conditions laid down by the state, subject to the fulfillment of which grant monies would be paid. But that is not the taxpayer company making a supply to the state of any sort.
But why is the position different in relation to the SFPE?
Well, if I purchase units of SFPE, my lord, that is acquiring an entitlement. Now, you might say, well, if a grant is outside the scope of that, there's no supply, why should buying the right to a grant be different? I think it's implicit in it. All I can say is that it's buying a right, and it was at the time anyway treated differently. It was treated as a taxable supply. I think if we all had our time again, my lord, that position might be revisited. But we are where we are, and unfortunately, that is the history on the basis of which we have got to here.
Yes, I see. So it may be anomalous, it may even be questionable, but it's past praying for.
Indeed, my lord. My lord.
So can I just make sure I understood? In your nutshell, your second condition was that the finance-raising exercise is itself outside VAT because no supplies are made. So I understand you to mean no supplies are made by the trader, that is the person who is seeking to deduct. Yeah, I do now understand that. I hadn't initially.
So, my lords, having established the basis on which SFPs are outside the scope of VAT, and before I go on to look at case law, some of which my learned friend has considered, I would like to make what I think is a very important not a clarification, but to flag up a point which I think it's essential to keep in mind when we are considering the matter before us today. This is, as far as best I can put it, as follows. We have, I think it is a matter of agreement that if inputs are used on the making of either exempt or outside the scope supplies, and I will call them downstream supplies. Downstream is a word used in Securenta and SKF. It's the downstream business. If the downstream business in which inputs are used is either exempt to any extent or outside the scope, then there is no doubt that the recovery of input tax is restricted. Now, that's a simple proposition, but it is at risk of being mixed up with the fact that the fundraising exercise in this case, and in many of the cases which I will look at, is also an exercise which is outside the scope of VAT. So we have the fundraising exercise, which is the immediate exercise, which is outside the scope, and then we have the downstream business, in which may be entirely taxable, it may be partially exempt, it may include activities outside the scope of VAT. Now, the proposition which I would like to make crystal clear is that there is no case in which the court, the European court, or any other court, so far as I know, has blocked the recovery of input tax by reference to the outside the scope status of the fundraising transaction. The courts have looked through the outside the scope status of the fundraising transaction and allowed or restricted deduction of the input tax on the fundraising costs by reference to the status only of the downstream transactions. Lord, it may be unnecessary to labour that point, but I found it very easy to forget when we encounter statements such as, if inputs are used in an outside the scope activity, there must be a restriction. Yeah. It's very easy to think that that outside the scope activity may refer to the funding activity itself. And in my submission, it is clear from the case law that it doesn't. The restrictive element, if there is one, is exempt or outside the scope activity in the downstream business.
So you'll be coming to the Welcome case in due course?
Yes, I think after lunch...
Don't let me take you out of your course.
I noticed reading it that, in fact, what was going on there was simply an alteration of the portfolio. They were selling their investments in order to reinvest the proceeds in different investments. It was no question of the money being, the proceeds of the sale being applied to medical research. So the sort of issue that we're dealing with doesn't seem to have been one that arose there.
Well, thank you, my lord. I will come back to Welcome, if I may, later. If I could start where my learned friend began with BLP, which is authority number 5, I don't think we need to go to it, because I just need to remind us of what we all know, really, which is that in BLP, there was the incidental costs of a share sale. The share sale was exempt. The parent company was trying to raise money for its wider use in the group, and it said on that basis the input VAT on the professional fees of the share sale ought to be allowable, and that was refused. The European Court said no, we can't look at your wider motives. Now, my lords, if that was truly where case law rested, we would not, I think, be here today. But in Abbey National, which I think was about 3 years after BLP, and Abbey National is in tab 4 of the authorities at page 695. again, if we look at the head note on page 695 for the facts, the company was a subsidiary of Abbey National PLC, a life assurance company, and the company with which we're concerned had an insurance business, which is an exempt business for VAT, and it also let out commercial property. And the company opted to charge VAT on one of its subleases, which meant that this particular building that Abbey National was letting was effectively a little taxable business. And then in 1992, the company sold the lease to somebody else, and you would think that would be obviously a taxable supply since the rents were taxable, but in fact, no. Another VAT complication comes along in the form of a special provisions order from 1995, which says that effectively, if a business is sold as a going concern, then that is a supply which is outside the scope of VAT. So the sale by Abbey National was outside the scope of VAT, and the question was what fell to be done with the input tax on the associated costs of the disposal. Now, in his opinion, Advocate General Jacobs drew a very clear distinction between the chain-breaking effects of exempt transactions, as in BLP, and the non-chain-breaking effect of transactions such as this one, a sale which was outside the scope of VAT. He said, in effect, we could look through the sale to the wider business and treat the incidental costs of the sale as an overhead of the wider business, so that part of the input tax was deductible. Now, you'll understand, my lords and my lady, that here we have a first attempt at or first chipping away at the monolith that appeared to be BLP. Because if the Advocate General is right, then in the case of transactions outside the scope of VAT, there is not the same chain-breaking effect as we have with exempt transactions. You'll recall that in BLP, as shareholding was being sold, that was an exempt transaction. There was an absolute block on the recovery of overheads. In Abbey National, it's a transaction outside the scope of the tax, and the Advocate General suggests that we can look through that. Now, excuse me, the court, in its judgment, effectively upheld the opinion, or effectively followed the opinion of the Advocate General. It's not absolutely clear that they accorded the same weight to the outside the scope principle as the Advocate General did, although in my note of argument I do suggest that there are grounds for thinking that the court was here following the Advocate General. At paragraph 16 of my note of argument on page 100, I refer to two paragraphs, paragraph 30 of the ECJ judgment and paragraph 42, where it appears to me that the ECJ is in fact following the Advocate General's approach. So the significance of Abbey National, I don't want to overstate it, because it involves it's the wider version of my proposition about outside the scope financing transactions. It's a transaction that did involve some supplies, but it was held that the professional costs could be treated as overheads of the wider business, and therefore BLP, the result of BLP is being departed from.
Well, either that or distinguished because it wasn't an exempt case.
Indeed, my lord, indeed. And the next case, which is the well-known one of Kretz Technique, Authorities tab 10, page 806, is the last one I'll deal with before lunch, if that is convenient. And I can deal with it fairly shortly, although it is a very, very, very important case, because it is dealt with at length in all the judgments of the court and tribunals below. Your lordships will recall that in Kretz Technique there was an Austrian company, I think, making medical equipment. It had a fully taxable business, and it obtained a listing on the stock exchange and issued new shares, a significant number of new shares to the public. And the question arose whether the incidental costs of the share listing and the share issue could be treated as overhead costs of the general business, and since the general business was fully taxable, whether all the input tax would be deductible. And there was an initial argument from the Austrian government that the share issue was in fact itself a taxable transaction, and that would block the deduction on authority of BLP. But the court held, first of all, that a share issue was not within the scope of VAT at all. It wasn't a supply. There was no VATable transaction here. And that the Austrian government's next argument in response to that was to say that, well, if there's no transaction here, there can be no deduction further down the line by reference to the downstream business, because the nearest, most proximate transaction to the incidental costs that we're looking at is something that's a tax nothing. But the CJEU, or the Court of Justice as it was, said no, that's not right. And the absolute key to their judgment is in paragraph 36, which is on MS page number 820. And there the court said, in this case, in view of the fact that, first, a share issue is an operation not falling within the scope of the 6th Directive, and second, that operation was carried out by Kretz Technique in order to increase its capital for the benefit of its economic activity in general, it must be considered that the costs of the supplies acquired by that company in connection with the operation concerned form part of its overheads and are therefore, as such, component parts of the price of its products. Those supplies have a direct and immediate link with the whole economic activity of the taxable person. And as I'm sure your lordships and ladyship appreciate, it is my case that the fundraising mechanism here, the claims to SFP, being an operation not falling within the scope of the 6th Directive, and having been carried out by the respondent company in order to increase I would say to increase its capital, I'll come back to that, for the benefit of its economic activity, it must be considered that the costs of the units of SFPE acquired by it in connection with that operation form part of its overheads and are therefore, as such, component parts of the price of its products. So, in other words, I rely on Kretz technique for the right to deduct the cost of units of SFPE in this case. And the first-tier tribunal thought that the case was on all fours with Kretz technique, and the upper tribunal and the inner house effectively were of the same view. I invite this court to the same conclusion. If your lordship is inclined to break there, that would be a convenient moment.
Yes, we'll be pleased to hear you again at 2 o'clock.